Hello, my name is Faisal Fasi. I teach in West Bengal National University of Juridical Sciences, that is NUJS. The topic of the discussion is strict liability offense. There are various theories available for understanding the meaning of crime. Some scholars, such as Blackstone, argue that crime is an act or omission which is wrong done to the public as a whole, rather than impact being confined to an individual. Some scholars attempted to define on the ground of moral wrong, some argued for procedural wrong, and the list goes on. The other ways of looking at crime is by understanding its legal definition, which is more practical approach for the modern day penal code and is also recognized and accepted by experts including a scholar of criminal law, judges, and legislature. The legal definition is represented by the legal maxim, actus non feci trium, nisi mensi tria. In other words, there are two elements of crime, namely actus reus, that is act or omission prohibited by criminal law, and mens rea, the guilty intention recognized by the criminal law. The common law presumes the requirement of mens rea except in cases of public nuisance, outraging public decency, and defamatory libel including blasphemy. Mens rea is also essential ingredient in the most of the offenses in the modern day criminal law. However, the word mens rea is not mentioned in the statute, but the import of mens rea has been provided by some technical words in the definition of offense. For example, in the Indian Penal Code, the terms such as intention, knowledge, reason to believe, voluntarily, dishonestly, and fraudulently denote the requirement of mens rea. So the prosecution has to prove the concurrence of a prohibited activity and a mental element. This is called fault-based liability. The obvious reason for the requirement of guilty intention or mens rea is to protect the person who has committed any act by misfortune. However, there are certain cases where individual may be punished merely for the act or actus reus, even though he didn't have any mens rea at the time of the incident. This is technically called strict liability or no fault-based liability. So at this moment, the question which pops up in the mind is why mens rea has been taken away from the essential element of crime. This led us to understand certain justification for imposing strict liability. Justification of strict liability. The background of strict liability may be traced back to the days of industrialization. There was a concern for the health and safety of the workers. In case of any mishap in the factory, it was very difficult to prove the mens rea of the owner of the factory, and consequently, lots of criminal litigation took place between trade union and factory owner. Further, the two world wars have played a very crucial role in the development of strict liability. Actually, the function of the state has been transformed from mere police state to welfare state after the Second World War. The police state was predominantly about maintaining of peace and order in the society by punishing the wrongdoer. But with the new constitutional mandate in the post-independent India, the state has to ensure the welfare of the people, which requires proactive action on the part of the state for raising the standard of living of the citizen by ensuring health, safety, sanitation of people, economic development, special care for vulnerable group, and so on. The directive principles of the state policy is relevant in this regard. Secondly, the theory of utility can justify strict liability. The utilitarian preached for the greatest good of the greatest number and assumes that an individual acts in a rational basis with the primary objective of achieving happiness. It is generally based on the consequence of an act rather than the act itself. The happiness of the public at large or greater good should prevail over individual happiness. It can be achieved by occasionally prosecuting an actor who has taken some care but may be held liable for the bad consequence by applying strict liability, denying the defense of reasonable mistake of fact or human error. For example, in case of essential commodity, the manufacturer may be held liable even if there is some problem in just one of the packets of food sold in a reasonable time out of million packets. Third, strict liability acts as deterrent for those who are incompetent for certain ventures. Again, we take the example of essential commodities such as food and medicine. Fourth, it expects higher standards for dangerous activities such as dealing in poisonous gases or chemical. It is done to avoid or at least minimize certain tragedies such as Bhopal gas leak case where millions of people were affected, and even after more than 3 decades of that incident, the suffering is on. Finally, it is argued that strict liability is perhaps the only solution where it is very difficult to prove mens rea, as one can appreciate that it is impossible to look into the heart of the actor. Having said this, there are certain counter arguments for various justifications provided in the favor of strict liability. But before going into the criticism of strict liability, I'll provide an overview of various categories of crimes where strict liability has been imposed. So coming to the subject matter of strict liability, as mentioned before, the strict liability is applied only in exceptional situations. Therefore, the court of law is not at liberty to apply, even if the consequences of the act are dreadful. In other words, there is always a presumption of mens rea, unless the statute excludes its expressly or necessary implication. The second guiding principle is that strict liability is generally applied for mala prohibitum offences. One of the ways to classify crime is into mala in se and mala prohibitum. Mala in se offences are those which are inherently wrong, such as murder, rape, etc. On the other hand, mala prohibitum offences are generally regulatory in nature. The case of Sweet versus Pasley explains this point. In this case, a teacher rented her house. The tenant was caught smoking cannabis within the premises, which was not permitted by the law. The teacher was found guilty by the trial court for the violation of the Provision of Dangerous Drugs Act of 1965 for mismanagement of the premises. The teacher appealed on the ground for the lack of knowledge about the activities for tenants and argued that it was not foreseeable for her to anticipate such activities. The court attempted to differentiate true crime with regulatory offense without any proper categorization and acknowledgement that strict liability was appropriate for regulatory offense. The court added that generally mens rea is essential for offense to which real stigma is attached. The court considered the instant case and true crime, and accused was not held liable by the appellate court for the lack of mens rea on the ground that the stigma would cause her lose job. Nevertheless, sometimes the demarcation between crime requiring mens rea and crime of strict liability becomes difficult. For tiebreaker, the judiciary considers certain parameters. First, the objective of the statute in question is perhaps the most important factor. Strict liability is imposed if the object of the statute cannot be achieved by reading mens rea into the provision. Second, the quantum of social danger is relevant. The greater the degree of social danger, the greater chances for construing it strict liability. So cases like Bhopal gas leak would always qualify for strict liability. Third, the judiciary interprets cases in the light of contemporary situation. For example, prior to demonetization of certain currencies in India, the government gave opportunity to people for disclosing black money for granting certain exemption from tax. In this backdrop, the interpretation in corruption matter relating to black money, tax evasion, etc. would be very strict. Fourth, strict interpretation is the settled rule in certain cases under social welfare legislation. Fifth, strict liability may be enforced in cases where it is difficult to prove mens rea. There is one common theme in all the strict liability offense, that is, it directly affects public welfare. I have attempted to categorize various strict liability offense into certain heads, even though there is a serious overlapping. Now we will check some of the common themes, popular themes of strict liability offense. The first in the list is regulatory offenses. This type of offense is not purely criminal, rather it is more in nature of civil rights. It is created through special laws. A special law means a piece of legislation which deals with only one subject, such as Arms Act deals with only issues relating to arms. Similarly, Motor Vehicle Act deals with only activities relating to motor vehicle. So Motor Vehicle Act punishes certain acts such as rash driving and use of mobile phone while driving. So it is not a valid defense for the driver that he took an urgent call while driving without actually having any malified intention to endanger life and safety of others. He will be held liable because the court will not go into the argument of mens rea at all. Similarly, a person would be held liable if he is riding a motorcycle without wearing a helmet. The important point to note in this case is that actual harm is not caused to anyone, but still strict liability is imposed because either the actor may cause or actually causes inconvenience to others or endanger life and safety of the actor itself. The second category is socio-economic offenses. Socio-economic offenses are those which affect the social and economic condition of the country and overall public welfare. The most important topic in this regard is white-collar crime. In fact, socio-economic offenses are often considered from the angle of white-collar crimes. White-collar crimes are those which are committed by person holding respectable position in employment. It is considered very serious and often offenders are punished even without mens rea. Cases relating to essential commodity also come within this head. In the state of Odisha versus Rajeshwar Rao, the accused sold adulterated cumming, which was in contravention of Section 7 of the Prevention of Food Adulteration Act 1954. But the trial court and the High Court acquitted him on the ground that his father was the owner of the shop. The Supreme Court set aside the order of acquittal and convicted him on the ground of strict liability. The Supreme Court of India has stated about the Prevention of Food Adulteration Act in the following words, to quote, "The act is a welfare legislation to prevent health hazard by consuming adulterated food. The mens rea is not an essential ingredient. The essential ingredient is to sell to the purchaser by the vendor. It is not material to establish the capacity of the person vis-a-vis the owner of the shop to prove that his authority to sell the adulterated food exposed for sale in the shop. It is enough for the prosecution to establish that the person who sold the adulterated article of food has sold it to the purchaser, including the food inspector, and that food inspector purchased the same in strict compliance with the provision of the Act. As stated earlier, the sanctioning authority has considered the material placed before it, whether the offence of adulteration of food was committed and punishable under the Act. Once that satisfaction is reached and the authority is competent to grant the sanction, this sanction is valid. It is not necessary for the sanctioning authority to consider that the person sold is the owner, servant, agent or partner of the owner of the duly authorized in this behalf. Similarly, in case of Sarju Prasad versus the state of UP, the employer was held liable for the sale of adulterated food by the servant under the Prevention of Food Adulteration Act 1954. However, these cases should be compared with the cases of Nathu Lal versus the state of MP. In this case, the accused was charged for storing food grain without possessing valid license for the same. He applied for the license and believed that it would be issued to him, but the application was rejected. However, the catch is the authority rejected the application without providing him opportunity for hearing. Besides, the authority did not intimate the rejection. Acting on the belief that the license would be issued, he was purchasing food items from time to time and sending returns to the authority disclosing his purchase. The Supreme Court gave the benefit to the accused by setting aside the order of the conviction passed by the High Court and acquitting him. Smuggling is another notorious subject matter in this regard. The leading case is M. H. George versus state of Maharashtra. In this case, the German national was charged under the Foreign Exchange Regulation Act of 1947, read with notification of the RBI and the Custom Act for carrying gold in the Bombay airport. He was traveling from Zurich to Manila, but the plane arrived in Bombay. One of the arguments of the defense was that mens rea was essential ingredient of an offense. The court noted the common law presumption of mens rea, but mentioned that the presumption may be displaced by the words of the statute. The accused was held liable. The court emphasized that the objective of Foreign Exchange Regulation Act was to conserve foreign exchange, which was essential for the economic survival and advancement of the country. The court have been following a strict approach in the cases relating to socio-economic offences. The third is the offense of public nuisance. Public nuisance simply means an act or omission which causes inconvenience or annoyance to the general public. It should be differentiated with private nuisance, which is a ground for civil action. For example, if a person throws garbage near the door of his neighbor, civil action may lie, but criminal jurisdiction may be triggered if the same garbage is dumped in the public place. In certain situations, civil as well as criminal action may arise out of the same case. For example, if a person digs a manhole in the public place and another person falls into it, action may be taken by the victim in civil law, and criminal case may also be filed by any interested member of the society. According to section 268 of the Indian Penal Code, a person is guilty of public nuisance who does an act or is guilty of an illegal omission which causes any common injury, danger or annoyance to the public or to the people in general who dwell or occupy property in vicinity, or which must necessarily cause injury, obstruction, danger or annoyance to the person who may have occasion to use any public right. A common nuisance is not excused on the ground that it causes some convenience or advantage. The term public is defined in section 12 as public includes any class of the public or any community. Public nuisance may arise out of lawful activities as well as unlawful activities. For example, law may permit installation of chimney in the factory, but if the smoke coming out of it causes disturbance to the people residing nearby the factory, it may qualify for public nuisance out of lawful activity. For example, in the case of Govind Singh versus Santi Sarup, the smoke emitted from the chimney was carried with a strong wind, causing conflagration and was considered injurious to the health of people. On the other hand, passive smoking in public place simply qualifies for nuisance, irrespective of the quantum of damages caused to the public in general, as laid down in case like Ramakrishnan versus the state of Kerala, that is 1999 case. Now we move on to the fourth category, which cover cases affecting the rights of vulnerable people. The Constitution provides for special rights for certain section of the people, and to ensure that the legislature has imposed strict liability in certain crimes. An offense of kidnapping of minor child could be a perfect example. Now imagine that a child of around 10 years, unattended by the guardian, is standing on the side of the road and he is crying. You being a passerby would generally inquire in this situation, just out of concern for that small kid. Imagine that you get the reply from the child that he is crying because he needs a chocolate. Your general reaction would be to check the caretaker of the child. And if he is not in your sight, chances are that you would buy a chocolate for that child. So you looked around here and there and you notice a chocolate shop on the other side of the road. Now you gently hold the hand of the child with the promise to buy a chocolate for him, and you are on the way to cross the road. Now, in the middle of the crossing, the father of the child comes and alleges you for an offense of kidnapping. In this scenario, even though you were acting for the benefit of the child, having no bad intention whatsoever, but you will be held liable for kidnapping. Similar kind of standard is followed in certain cases of offenses against women. Person belonging to SC, person belonging to ST, and other classes of vulnerable people. Next, strict liability is also imposed when criminal act is targeted directly against the state, such as waging war against the state, misuse of official secrets of the state, and various other unlawful activities. Finally, strict liability is also imposed for protecting rights of the workers who are working in the factory and dealing with various equipments, machineries, etc. In the case of JK Industry Limited versus Chief Inspector of Factories and Boiler, the Supreme Court observed the offence under the Act, that is Factory Act 1948, are not a part of general penal law but arise from the breach of a duly provided in the social beneficial legislation, which creates absolute or strict liability without proof of any mens rea. The offences are a strict statutory offence for which establishment of mens rea is not an essential ingredient. The omission or commission of the statutory breach itself is an offence. Similar type of offence based on the principle of strict liability, which means liability without fault or mens rea, exists in many statutes relating to economic crimes as well as in laws concerning the industry, food adulteration, prevention of pollution, etc. The whole idea is to promote the welfare aspect of the laws, protecting the right of the worker. This theme may be clubbed under the category of vulnerable group. Apart from the set categories, there are several other subject matters where strict liability may be applied, such as acts which obstruct the administration of justice, like certain acts under the Contempt of Court Act of 1971, acts which degrade the environment as laid down in various cases of MC Mehta versus Union of India, and offences relating to decency and morality. The case of Ranjit Udesi versus the state of Maharashtra, that is 1965 case of Supreme Court, is relevant in this regard. The court found content of the book obscene. The title of the book was Lady Chatterley's Lover. The accused bookseller argued that he was not aware of the content of the book and hence didn't have mens rea. The court convicting him under section 292 of the IPC by pointing out that there is no import of mens rea in the provision. So it's time for disclaimer. The above list is not comprehensive enough to include all the cases of strict liability, but it covers most of the cases. Now coming to the criticism of strict liability. So before we end, I would like to point out few criticism of strict liability. It is interesting to note that certain scholars have argued that strict responsibility is not an offense at all. For instance, Professor Jerome Hall argued that strict liability may be called as economic law or administrative regulation rather than a criminal liability. Apart from the fact it is against the basic premise of criminal law, that its effectiveness is also questionable, because we are aware that consumer complaints relating to substandard products and services have not reduced, rather it has increased in the present capitalist society. Sometimes it also creates an atmosphere of unfairness. The case of Pharmaceutical Society of Great Britain versus Stogwen Limited could be cited as an example. In this case, a person presented a forged prescription for purchasing controlled drugs. The chemist attempted to verify the presentation or rather prescription by calling the number given in the prescription, which was the procedural requirement provided by the regulatory body. The receiver of the call, who had colluded with the customer, confirmed the genuineness of the prescription, and the chemist handed drug to the customer. Now what is interesting to note, the busy chemist was held guilty even though he made an attempt to fulfill the procedural requirements. Nevertheless, offense of strict liability are recognized by the legislation and precedent in the criminal sense. To sum up, with due respect to all the criticism, the modern day penal statute incorporates strict liability in certain situations. However, still the general principle is to punish a person under criminal law, mens rea should be provided. While interpreting cases, the court gives a special emphasis to the objective of the law and the repercussion of the incident in question. Thank you.